May it please the Court. I'm Bruce Jones representing Matthew Construction in this case. I'd like to make two initial points. Storms is treating the subcontract here, the P quantities in the subcontract, as if it were a lump sum contract, which it is not. Many of Storm's arguments rest on this presumption. Its argument concerning risk allocation, its argument concerning windfall, its argument concerning partial performance, all of that assumes that this is a lump sum contract. It is not. The contract here depends on, the P quantities here depend on the plan that controls the construction of this highway project. And the plan has not changed. The plan is subject to verification. The plan is subject to adjustment and correction as set out in 1901. So this is not a lump sum contract.
When you say it's not a lump sum contract, what you mean is that it's ultimately determined by the amount of material that's involved, and that's measurable.
No, it's ultimately determined by the plan, the measurements on the plan.
Well, but the plan is dependent on measurements. I mean, the plan calls for measurements.
Right. The plan includes measurements which are then calculated here incorrectly into the P quantity that is defined in the contract. Here, the plan has not changed. The measurements that defined the amount of work that Storms had to do here has not changed. It is simply that as the project progressed and as Storms discovered that it was taking much less time to do the work that it had been hired to do, they discovered there was a serious miscalculation in the P quantities. That calculation was corrected, but the plan itself did not change. And as a result, the P quantities were adjusted and were corrected, and those corrections are binding on.
Counsel, could I ask you a preliminary question? Opposing counsel spends, I think, 25 pages talking about why we should dismiss this case as improvidently granted. And there was one aspect of the argument that concerned me that I'd like to give you a chance to respond to, sort of as a preliminary matter, which is the fact that we don't have the specifications in the record, or the entire specifications in the record. And sort of my initial question to you is, without downloading any of them from the from the website of the Minnesota Department of Transportation, is there enough in the record to decide this case under your theory of the case?
Yes, there is, Your Honor.
The excerpts are sufficient that were placed in the record are sufficient to decide the case?
Yes, I believe on the reply brief, on page 4, we listed even under Storm's own version of what went into the record at the trial court level, there was sufficient. There was 1402.1, 2, and 3. There was excerpts from 1504. There was 1901. And there was an excerpt from specification 1903.2, which are the critical issues here. And certainly the Court of Appeals relied on 1901 in reaching its decision because it depended on the distinction between the supposed conflict between Section 10A of the subcontract and Section 1901. So I believe there is enough in the record, even if you didn't go to the website, to decide the issues that are presented in this case. But I would also submit that you are free to go to the website based on the Court's previous holdings that government policies and specifications issued pursuant to statute may be, and that are incorporated by reference into a contract, may be considered and may be read.
Well, I question that. I mean, we have certainly done that with respect to regulations, but I think the difference is the regulations and rules passed by a regulatory agency are available on Westlaw. They're freely considered sort of binding legal materials, even if they're interpretive in nature. With respect to a specification, it's not clear to me that we've ever held that you can go to a web, and I actually looked for these on Westlaw and couldn't find them, the specifications. It's not clear to me that we can go to a government body's website and download documents that may or may not be incorporated in particular contracts. Am I wrong about that?
I believe the case law does support it. I will also point out that Storms itself in the Court of Appeals did exactly this thing. So any objection they have to it, to the present Court's use of those documents, has been waived because they not only told the Court they could use them, but they cited them to the website themselves 12 times in the course of their brief.
Counsel,
Yes.
please complete your sentence. I interrupted you.
No, I was just going to repeat that they are in the record from the trial court as well.
Counsel, I'm trying to figure out what is and is not in this case. What clearly is in this case is the subcontract. We have a copy of that in the record.
That's correct.
Now, Section 20 of the subcontract deals with final payment, and Section 21 contains what looks to me to be a pay-if-paid clause, a condition precedent to the obligation of the contractor to pay. Is the issue of whether payment is due under Sections 20 and 21 of the subcontract in or out of this case? And I'm going to ask opposing counsel the same question.
If you'll give me a moment to go. Section 20 is in this case to the extent, and we've quoted it in one of our briefs, that it says that the, I apologize. There is a provision in Section 20 that says that all final payments, or all payments previously made are subject to adjustment at the conclusion before the final payment is made. And that aspect of Section 20 is relevant to the issues in this case.
Okay, how about Section 21, which says that payment from the owner is a condition precedent for payment by the general to the sub? Is that in, or has that been argued in this case?
That was not raised in the trial court, Your Honor, and is not part of this case.
Thank you.
Mr. Jones, I want to go back a little bit further, maybe from where Justice Lillehog is. I'm looking at page 6 of your brief, and I will say I appreciated you laying out the different forms of methods of measurement. That was helpful to me. But I'm still a little bit unclear, and I just want to understand this before we get into, Spec 1901 and 10A of the subcontract. You say that measurement by plan dimension is based on the dimensions that appear in the original plan documents rather than on actual physical measurements in the field. If that's true, where do the dimensions come from? I'm just trying to figure out how it's initially determined what the plan dimensions are.
For example, if the project you have is going to need a hole filled with dirt that is 10 yards wide, 10 yards long, and 5 yards deep, those dimensions can be calculated into a P quantity of 500 cubic yards, and that P quantity then goes into the estimate. What happened here was you had the hole on the plans correct. It was 10 by 10 by 5, but because of a mistake in the calculation, the P quantity was calculated to be 1,000 cubic yards rather than 500. So the plan was correct, but the P quantity, because of the mathematical error, was wrong. And that's what was caught later on, and that's what was corrected. So the plan itself never changed. It's just the mistake in calculating what the plan would require.
Which is why your argument is that Spec 1901 is does not conflict, or is not in conflict with 10A of the subcontract, because those are two different things.
That's correct, Your Honor.
Okay.
Section 10A and 1402 as well deal with changes in the work, particularly in the nature or scope of the work, and that's not what happened here.
So stay with the example you just gave me. How would that play out?
Okay. If halfway through the project, MnDOT had said, wait a minute, that's not going to be deep enough. We need to expand that for another 100 feet. That would be a change, and depending on its scope, it could be a change that was significant under 1402. Here, we don't have that. Here, we have the whole and the amount of work that was supposed to be performed by Storms has remained the same throughout. It's just that Storms, when it was doing it, discovered, wait a minute, this is not taking nearly as much work and as much fill as we thought. They pointed that out to MnDOT. MnDOT said, yes, you're right. They went back and looked at the calculations, discovered the error, recalculated it, and went from there.
Okay, thank you.
The
10A is about the scope of the contract, and 1901 is about the arithmetic?
in this case, yes, that's right, Your Honor. 1901 has other applications, but here that's what it's about.
So the plans are part of the record, and the plans, an engineer could look at them and replicate the calculations and see that there was a calculation error here?
The plans themselves are not part of the record. There's a description of the plans, and there's the calculation, the corrected calculation from the plans is part of the record. It was attached as an exhibit to the affidavit of Mark Anderson, who worked for the MnDOT engineer on the project, and that was submitted in the trial court. So you can look at the calculations from the, it looks kind of like this. You can look at that calculation. There's no dispute between the parties that the plan didn't change and that the issue here was created by...
What I'm trying to drill down to is that, to me, and I may be completely wrong about this, that the issue boils down to whether what happened here was a change order under 1901 or under 10A. And I'm trying to figure out if there's enough in the record for us to make that to review that determination. So I guess, first of all, do you agree with me that that is the underlying issue on the breach part of it? I'm not talking about the damage.
Yes, I would agree, Your Honor. And to go to your question, if you take a look at both the affidavit of Mr. Anderson that was submitted to the trial court and his testimony at trial, he lays out exactly what happened in terms of the sequence of events. We set it up, we calculated it, we got out there, it was taking much less time, and so we recalculated it and discovered our error, and we let Matthew know. And by the way, Storms was aware by the time they finished the work that the calculation had been mistaken.
Counsel, I'm puzzled about, as a practical matter, how this deduction occurred. MnDOT deducts $327,000 and change from Matthew's contract, correct?
Correct.
And then Matthew deducts $327,000 and change the same amount from Storms' subcontract, correct?
Correct, yes.
Did Matthew not mark up Storms' work in any way? In other words, why is there a dollar-for-dollar deduction going down the chain of privity?
Because, I mean, that's... I'm not completely certain of the focus of the question.
Well, normally subcontractors put in their bid for a scope of work, and then when their bid's accepted, the general contractor will usually mark it up in some way in its own bid to the contractor for the general contractor's own overhead profit and so on. And so it's just I just thought it was kind of odd to see a $327,000 deduction going from the owner to the general and then the general to the sub. That would suggest the general hadn't marked it up in any way.
Well, the record here doesn't reflect that either way.
We don't know why.
We don't know why.
Counsel, I had just another maybe more practical question as well. I'm looking at Mr. Anderson's, I think it's in Anderson's affidavit, but it's also in the district court's findings of fact on ADD 34. And respondents bring this up in their brief, that initially Matthew requested payment for the work provided based on the original plan dimensions. So if you thought the plan dimensions were wrong, why would you go back to the Department of Transportation seeking the original amount based on the original plan dimensions? That seems inconsistent to me.
Again, the record is not completely clear on why that happened in the way it did. It did happen as you described. At that point, I mean, Matthew had been informed in June of 2014 that there was, I'm not sure the year, but had been informed in June that this mistake had happened. There were meetings going on between MnDOT and Storms to try and resolve and ask for documentation of any lost fixed costs that resulted in light of this. It may have been that Matthew was simply doing what Storms asked it to, submitting this, trying to get the process of negotiation moving, but it's not clear from the record. The fact is, as soon as the change order was made, that was conveyed on by Matthew to Storms. Because at that point, the original contract hadn't been formally modified. So the request was made based on the original contract at Storms' request. Okay. One of the main issues in here is the the supposed conflict between Section 10A and Specification 1901, which, according to Storms, means that Section 10A overrides 1901 and requires that any change be made during the pendency or during the progress of the work. I submit to you that for two reasons that conflict does not exist. First, as I've mentioned, Section 1901 and, Specification 1901 and Section 10A address very different issues. One permits the correction of an arithmetic error in a P quantity based on an unchanged plan, and the other, Section 10, deals with actual changes in the work. So they're addressing different issues, and as a result of that, you don't have a conflict between them. Even if they did address the same issue, however, Section 10A does not impose a temporal requirement. It does not say that any change has to be made during the progress of the work. The Court of Appeals relied on what it said was the plain language of Section 10A and quoted the phrase progress of work. That phrase does not actually appear in Section 10A, and the Court of Appeals was mistaken. Probably acknowledging this, Storms does not argue in its response that the language is there or that the court can rely on that language, progress of work, but nevertheless argues that the plain language of 10A does impose a temporal requirement.
Well, it is in 1402, right?
It is in 1402. The problem with relying on 1402 is threefold. First of all, again, 1402 and 1901 address different topics. They're not, one addresses changes in the nature of the work, the other addresses correction of P quantities. Second, the work that 1402 describes, when it says progress of the work in 1402 is the work of the contractor, Matthey, not the subcontractor, Storm. If you take a look at the definition of work under the specifications, and under 1103 of the specifications, work is defined as the furnishing of all labor, materials, equipment, and other incidentals necessary or convenient to the successful completion of the project and the carrying out of all the duties and obligations imposed by the contract upon the contractor. And the contractor is Matthey. It's also used to indicate the construction required or completed by the contractor. So they can't rely on the progress of the work for 1402 because that refers to Matthey's work, not the much smaller subset of Storm's work. And the third problem with 1402, if you will allow me a Rick Perry moment here.
1402 doesn't seem to have the limitation that you're suggesting, limiting the work to the of the contractor. It just says the department may alter the details of construction as necessary for proper completion of the project. It seems more general, and I guess what I was hoping that you would focus on is that, as I understand Storm's argument, they're saying that there's some overlap between effectively 10A and 1901, and at least in the 1901, and I'm looking at 1908, for example, there's a reference to certain estimates, which seems like it is that there. I mean, the terms are not neat and as precise as I was hoping that they would be when I read them.
So your question is, I mean, that they are called estimates. I mean, if you take a look at the list that includes the P quantities is called the Statement of Estimated Quantities. There's a recognition in the construction industry and by MnDOT that nothing ever goes exactly as planned, and there are always going to have to be adjustments, and both in what is done on the site and in the payment for those. But when you're talking about a major change in the character of the project, you're talking about 1402. Here,
yes, what I'm pushing you on is changes in work could be changes in the amount or the estimate. Why couldn't it include a change in the estimate of the calculation of the amount of material required?
Because that wasn't changed, that was corrected. As I mentioned before, the plan didn't change. It was simply that the amount of material required for the P quantity to fulfill the plan was miscalculated. And so there was no change in the plan.
Counsel, isn't that, and tell me if I'm wrong, if you look at 1402.1A1, it talks about the work is altered may require performance of increased or decreased quantities. So what's that mean? If that isn't also...
You're looking at 1402.2.
1402.1A, where it says altered work. And then sub 1 under that, paren 1 says the work is altered may require performance of increased or decreased quantities. What's that referring to?
That's referring to, certainly you could posit a change in a project which would require a substantial increase or decrease in the amount of some material that was involved. It doesn't address, here we don't have an increased or decreased quantity. The plan which defines the quantity is the same. It hasn't changed. It is...
Okay, I see what you're saying.
I
got you. I see what you're saying.
If you take a look
but Counsel, let me follow on one other thing, a little bit different. I think I understand your point there. Thank you. It's my understanding that Storms is arguing that this section applies, 1402 applies, and that any alterations in scope must be issued during the course of the work. As I understood the district court's order, originally the district court agreed with that interpretation. The district court later changed its mind and said, no, 1402 doesn't apply. Specification 1901 is the applicable spec. What I can't remember now, and I'm hoping you can refresh my memory, is what changed the court's mind? What happened in that interim? What was the rationale for the court's change in decision on that?
Well, the rationale appears to have been, and if you take a look at the trial transcript at the damages trial, the trial court, Judge Fabian, got more and more concerned about a potential windfall to Storms as a result of this out of the public coffers. And he mentions the word windfall several times in the transcript, and the attorneys are also arguing whether or not the summary judgment should be modified or summary judgment ruling should be modified. But as you say, he did seem to come around from his original determination that 1402 did apply to conclude that 1901, and particularly the damages provisions of 1903, in fact, were the ones that he had to apply there.
Counsel, I want to go back to Justice Stietzen's question and Justice Hudson's initial question. I'm trying to figure out, how fine of a line it is between the application of specification 14 and 1402 or 1401 and 1901. I don't know how highways are made, so excuse my ignorance on this, but suppose that you have a calculation, P quantity. They think, boy, we need this much fill. And they get to the site and Storm says, well, geez, all this fill that's in here is just fine. We actually don't need all the fill that we specified. So is that a change in the scope of the work when they realize they need half as much fill as they originally did? Or is that a change in P quantities, and that's similar to what you would argue should be the rule in this case?
That would effectively be reducing the size of the hole. You decide you don't need 10 by 10 by 5. Half of it is fine, so you only need 5 by 10 by 5. And that would be a change in the work itself, in the nature of the project, because it was anticipated you'd be putting in new dirt, and instead the dirt that's there is fine, and you don't need that expense. So that would be more in the nature of a 1402 change. It would involve a change of the plan itself.
So what Justice Anderson asked you about arithmetic errors. What other situations would Spec 19 apply other than arithmetic errors?
1901?
1901, excuse me, yeah.
If there were an error in, for example, just off the top of my head, if the plans called for a particular type of material to be used, and in translating that plan into the P quantity, you identified a different type of material, a specialized aggregate rather than a common aggregate, that would be another example of the type of correction that could be made under 1901, other than an arithmetic error.
Okay.
Counsel, I asked you about sections 20 and 21 of the subcontract, and you referenced that your client was relying on section 20. Either now or on rebuttal, could you point me to the portion of your brief that discusses section 20? I just did a quick word search and I couldn't find it.
Okay, I will do that. Thank you.
Following up on Justice Strauss's question, I guess this is what concerns me. As I read 1901, the second line, at least as I'm looking at it, talks about revisions to the dimension of the work, and paren, in which case only the affected portions will be determined, end paren, or when the engineer decides that the quantity designated as P is incorrect. And as I understood it, we're talking about the or clause. We're talking about a calculation, the 10 by 10 by 5, that's on the plan but was due to an arithmetic error or just a calculation error is wrong. What was concerning me is that the first part of that seems much more broad, revises the dimension of the work, and that seems to fit in to something more broad, that the engineer would come in and say, well, instead of a hole that's 10 by 10 by 5, I want to revise that and have the hole be 20 by 10 by 5. Is that, in your view, covered under 1901 or 1402?
Well, the change in the P quantity would need to be done through 1901, and that's the situation that Justice Strauss was talking about a moment ago. If you discovered that the dimension of the plan actually had to be changed, I can see situations in which 1402, it would be significant enough that 1402 would apply to that. I can also see situations where it would be de minimis. The fact is, that's not the situation we have here. We have, as you said, after the or clause, we have a situation where it was discovered to be incorrect from the beginning. The plan was correct. It was the P quantity that had been miscalculated. Okay. The last thing I wanted to talk about briefly is Section 1903. The Storms argues that Section 1903 bars any defense here because Matthew and MnDOT did not go through the procedures required by 1903 in order to reduce the amount of the P quantity. But that misunderstands what 1903 is about. 1903 only comes into play once you determine the final quantity. In fact, that's the first few words of 1903. It says, if the final quantity, I'm talking about 1903.2a, 1903 is intended to permit contractors whose P quantities have been reduced as a result of a miscalculation or for some other reason and have suffered as a result uncompensated fixed costs because they anticipated they were going to have a much greater role in the project than they did, to come in and prove those document those fixed costs and obtain a recovery of those fixed costs, not by changing the quantity of the units, but by changing the unit price of each unit, so that although the quantity of units has been reduced, the price can be raised slightly to compensate for the lost fixed costs. That's what 1903 is for. The burden is on the subcontractor here, Storms, and that's what, as you'll see in the record, the MnDOT was trying to do in November and again in January when it sat down with Storms personnel and said, look, we realize we miscalculated this, we screwed up, we need to make you whole, but you need to give us some documentation of what your fixed costs are. And at one point even offered $43,000 as a settlement of saying, okay, we know you can't get it, and we just want to resolve this thing. Even at the time of trial, MnDOT was still willing to do this, but Storms never took them up on it and never was able to produce any evidence of its fixed costs, including at trial, which was, of course, what resulted in the judge at trial finding that they had failed to prove their damages.
Counsel, I just have one quick question about the record for you when we were talking about what excerpts were in the record, actual excerpts of specifications. And I missed maybe, did you say that specification 1908 was one of the excerpts that was in the record?
I don't know that whether 1908 was or not.
Okay,
I'm not certain of that.
okay, thank you.
With that, I say my time is up. I will,
Yes, you have 5 minutes for rebuttal. Mr. Flaherty.
thank you, Your Honor.
May it please the Court, Scott Flaherty with the law firm of Briggs & Morgan for Respondent Storms Incorporated. This appeal boils down to a simple concept that flows throughout the specifications and the subcontract, and it is that price and quantity are not the same. They're not interchangeable. Both the specifications and the subcontract reflect that the means by which price is changed is not the same means by which work or quantity is changed. The procedures set forth in the specifications and acknowledged by the subcontract were not followed here, and thus the payment owed to Storms was never changed.
Counsel, as far as money is concerned, it looks to me like sections 19, 20, and 21 of the subcontract basically say your client doesn't get paid unless and until Matthew gets paid by MnDOT for that work. Are 19, 20, and 21 in this case or not? Or are we only arguing about 10A?
They are not in this case, Your Honor, and actually Section 18 also reflects that notion, 18A2 in particular. If the Court examines Matthew's answer...
That's true. It's 18A2 says condition precedent.
Correct. If the Court examines Matthew's answer in this case, it will see that Matthew never raised the affirmative defense of condition precedent. It raised a different affirmative defense of condition subsequent. That's also not an issue now in appeal. But Matthew never raised that condition precedent, so that's not part of the case. And the Court of Appeals, of course, didn't rule on it either. To some extent, this case is merely about who bears this risk of non-payment between the two parties to the case. It's not disputed that the mistake here was made by MnDOT, and whatever happens in this appeal is not going to be paid for by MnDOT. Either Storms will pay for it, Matthew will pay for it, or some combination of the two. There isn't a conflict between 1901, Section 10A, or any other provision of the specifications and the subcontract. From the briefs, all the parties seem to agree that all of these provisions should not be read in isolation, and if possible, should be read to give harmony to each other and to give effect where they apply. It's Matthew's interpretation of 1901 that causes a conflict between some of the other provisions of the specs, including 1402(2)(c). Here, the subcontract and the subcontract defines work, that the list of items in Section 3 of the subcontract is a lengthy description of the work that begins on addendum page 19 and goes all the way through addendum 22. Any change to the items, quantities, or prices in that list is a change to Storms' work by definition. The question then that was before the Court of Appeals, is it consistent with the subcontract and the specifications for work to be changed, Storms' work to be changed, after Storms had completed its work? All four judges who have looked at this case correctly concluded that Storms' work cannot be modified after it's completed. Section 10A reflects that. Any modification affecting subcontractors' work is the phrase in 10A. Once the work is complete, there's nothing left to affect. 10B also references to make changes within the general scope of this subcontract. This subcontract has a time is of the essence clause. Storms was penalized if it didn't complete it.
Counsel, when under this subcontract and under the general contract is the work complete? Isn't the work complete at the time of acceptance of the work by the owner?
The district court found, and this finding was not clearly erroneous, that Storms completed its work on Highway 44 1 year before the change order and the work on Highway 76 9 months before the change order.
I'm talking about as a matter of law. In construction, when is work complete? Isn't it complete at the time the owner accepts the work and then the warranty period begins to run?
Completion and acceptance are not the same. Storms' work was complete when it had no further duties to perform under the subcontract, and in fact, it is Section 3B on addendum page 22. This is not in Section 10, but it goes to this question. That says the work of the subcontractor shall be substantially complete in accordance with the schedule.
Substantially complete.
And so it acknowledges there may be some insubstantial completions, de minimis things that may occur a day or two after this completion. But this is a time is of the essence clause. And
Was Storms' work finally complete?
The district court found it was complete.
Did it find it was finally complete?
It only used the word complete.
Okay.
While we're on 3B, 3B is another provision outside of Section 10 that confirms Storms isn't on call, so to speak, for the duration of the general contract, such that a change order can issue, say, a year later, forcing it to do more or different or less work. 3B reflects that the contractor may not modify the schedule except during the progress of the work. Now, this is talking about time, not payment, but again, it's consistent with what both courts found below, that only during the progress of the work, and again, this is capital W work, this is referring to Storms' work identified in this Section 3.
But no one, as I understand it here, no one is asking Storms to do more work, right?
That is correct, Your Honor.
And so this is an argument about, I suppose the other side would use the term windfall, you would use the term contract price or something like that, but this is an argument about who gets that windfall / contract price.
We would frame it differently and say, in any contract and subcontract relationships like this one, both parties know that there's uncertainty at the outset. Mistakes will be made, conditions may be changed, things like that. And so they contract, both parties contract in the face of that uncertainty. And the specifications and the subcontract reflect a procedure by which measured quantities can be changed under 1901, and procedures whereby payment can be changed under 1402 and 1903, among others. So the issue of windfall presupposes, incorrectly, that the parties don't know there is this uncertainty. They're contracting in the face of the uncertainty, and that's why they set forth these procedures that cause some parties to bear the risks in certain circumstances, other parties to bear the risk in other circumstances. On different facts on an identical case, perhaps, this may have been disposed on the pleadings on a conditional precedent defense.
Counsel, let me just, I want to step back.
Condition precedent.
Just to step back for 1 second, let's leave the subcontract aside for a moment, because opposing counsel would have us really focus on the specifications. And you alluded to this in your answer. You talked about payment versus quantity. And what is your view of how to, again, leaving the subcontract aside, how would you interpret 1901 and how would you interpret 1402? In what circumstances do those separate specifications apply?
So 1901 tells us how it applies. It applies when the engineer revises dimensions for the work or when the engineer decides that the quantity designated as P is incorrect. It can apply with or without 1402. So they both can apply, or there may be situations where 1402 doesn't apply. And we know that from the text of 1402. 1402.1 contemplates altered work that requires the performance of increased or decreased quantities. That's contemplated in 1402.1. 1402.2 also contemplates significant decreased quantities. 1402.2c says that a significant change includes when a major contract item of work is decreased below 75% of the original quantity. So if both could apply, for example, the engineer reduces the quantity under 1901 and that reduction causes the quantity to fall below 75% of the original, then both apply. There are other situations where it wouldn't. A quantity change under 1901 may not, in all cases, be a significant change under 1402.2c, and then 1402.2c wouldn't apply, and perhaps there would be no price change at all. Both 1402 and 1903 contemplate that within this band of 75% and 125%, quantities may change, but payment may remain the same. This case is an example of that because on one quantity that Storms bid on, there actually was an overrun. Storms had to use more materials than were designated in the p-value, and it didn't seek payment for that because, as has been our position, no price change occurred.
You know, I wanted to ask you too, I asked opposing counsel, the one ground in which you call for this court to dismiss as improvidently granted is the fact that we don't have all the specifications. Are all the specifications that you relied on, the specifications that opposing counsel relied on, are those all in the record, or are some of them not in the record, at least in this conversation?
In my answer to your previous question?
Yes.
So, in terms of, just for clarification, for the summary judgment determination or the trial determination, or either?
Either. That we have them on appeal in the record.
1901 is, a one-page excerpt of 1903 is, 14022C is not. So that would be the problem. Now, to be clear, if there are really three different records here, to be clear. There is the summary judgment record, there's the trial record, they're not the same, they have different documents in it, and then there's the appellate Rule 110 record on appeal. That's the broadest, that's everything filed in the district court. So the 110 record, because of Storms' post-judgment motion, attached all of Division 1 of the specifications, basically the first 2,000 specifications. They are in the record on appeal, but they were not before the district court. And the district court issued its decisions on what was before it at the time it ruled, and the Court of Appeals appropriately reviewed the district court's decision based on what was before the district court when it made those rulings. 1504 instructs that users of the specification, and implicitly courts that are considering them, are to construe terms in them with reference to the headings and titles. That's from 1504. The titles here confirm Storms' reading of the specs and undermine Matthey's. The title of 1901 has nothing to do with payment or money. Its title is measurement of quantities. And throughout 1901, it talks about the engineer measuring quantities, revising them, computing quantities. 1901 is all about quantities. And that's why it doesn't conflict with Section 10, and why it doesn't conflict with 1402.2 when that applies. The portions of the specification that talk about price and payment and changes to price and payment, those do so explicitly. The title of 1903.2 is price adjustment. The title of 1903 generally is compensation for increased or decreased quantities. That's what happened here. The engineer decreased the quantities a year after Storms completed its work.
So, counsel, then, how do you deal with spec section 1908, which gives the MnDOT engineer express power to prepare a final statement after the project is complete, showing accepted quantities and showing that all estimates are subject to correction in the final statement?
Two responses to that, Your Honor. The first response is that was not part of the summary judgment or trial record. The second response is that goes to the condition precedent defense that was never raised here. This would be a very different case, I think, if the district court had considered that, or if the Court of Appeals had considered 1908, or if that had been raised at all.
So your client's position is we can't consider any of the condition precedent language in subcontract sections 18, 19, 20, and 21, and we can't consider spec 1908.
Correct, Your Honor. The civil rules say the failure to raise an affirmative defense is waiver. It was waived long ago in the trial court. There's been no question, but just for the sake of clarity, I want to make clear why Storms believes 1402.2 applies to it. Because, of course, Storms, Matthey, and MnDOT are not interchangeable, either under the subcontract or under the general contract or the specs. Section 12 of the subcontract states that Storms has the same rights against Matthey that Matthey has against MnDOT. And the right at issue here, of course, is the right under 1402.2C, where once Storms' work is complete, its work cannot be altered. Matthey has that same right against MnDOT under 1402.2C, but of course that was not litigated below.
Counsel, is your client seeking its fixed costs here, or are you rolling the dice for the whole 327?
We are seeking now what we sought and received from the Court of Appeals for a new trial on damages. What the district court did over and over repeatedly, it said it was doing equity, it wanted to do what was fair. It didn't, it could have but didn't, revise and change its summary judgment ruling. It did the equitable thing. At that new trial on damages, which still should occur, we may or may not seek fixed costs or something else.
But, you know, if we're talking about who's bound by pleadings, I'm looking at your client's complaint, the summons and complaint, and as I read it, it's just basically saying we're entitled to $327,000. There's no pleading in the alternative for fixed costs, no pleading in the alternative for lost profits. It looks like all or nothing. Isn't your client bound by the complaint?
I think that's fair, Your Honor, yes. And that's part of the reason we asked on appeal in the alternative for a money judgment from this court in that full amount. Because once this court finds that the specifications and the subcontract set forth a procedure by which the payment to Storms is owed, and that procedure wasn't followed, it's almost a necessary conclusion that that's the exact amount Storms is owed.
So you would agree with the district court's conclusion that your client didn't put anything in the record showing its fixed costs with respect to the $327,000 of deducted payment?
Storms made no showing of fixed costs. That's correct.
Okay, so that issue in this case is done. Am I correct on that?
Yes, Your Honor.
Okay.
Seeing no further questions, we ask the court to affirm the remand issued by the Court of Appeals.
Thank you, counsel. Mr. Jones, you have 5 minutes for rebuttal.
Thank you, Your Honor. First of all, Justice Lillehag, I was mistaken. We did not cite to Section 20 of the subcontract. What I recalled was a quotation from Section 1908, which it was refreshed when you talked to my opponent about that. That's what brought that back to mind. That's what I quoted.
And speaking of spec Section 1908, is that in the record?
It is. I don't believe it is in the. I don't believe it was ever formally submitted to the trial court. I know it was relied on by parties, and as I said, it's my belief that the court can, as the Court of Appeals did, look at the specifications as they exist on MnDOT's website.
Okay, so whether we can consider 1908 depends on your argument as to whether the published specifications may be considered generally. But let's talk about 1908 in particular. It looks to me like this may be one of your client's strongest arguments, that the MnDOT engineer can, in fact, prepare a final statement showing accepted quantities. All estimates are subject to correction. If we conclude, though, that we don't have spec 1908 in the record, what should we do with it? Should we remand the case to the district court for consideration of 1908? Where does your client stand on that remedy?
I don't think you need to do that, Your Honor. I think that this provision, section of 1908 that you and I are talking about concerning final adjustment simply reflects what the specifications over and over again talk about. It's in 1901 in terms of correction of errors. It's in 1504, the passage that was quoted a moment ago, where it says that neither party, quote, may take advantage of any error or omission. Those are both clearly in the record, and I think they serve the same function as the language we're talking about from section.
Do you agree with counsel's argument that your client has waived the condition precedent concept? That is, the idea that Matthew needs to get paid by MnDOT before it owes anything to Storms?
You're talking about section 18?
18, 19, 20, and 21.
That was not raised in the trial court, Your Honor.
So did your client waive it?
I would have to say we did. Turning to a couple of other comments, Storms has said, I was struck in particular by saying that, by Storms' attorney saying that either Matthew will pay for this or Storms will pay for it. That's very misleading. There is nothing here for Storms to pay for. Storms does not dispute that it never spent the money that it would have taken for the labor and the materials for the original P quantity as it was stated in the original contract. There's nothing there. They haven't expended that money, and so there is nothing for them to lose. The only loss here can be the creation of a windfall in favor of Storms at the expense of Matthey. Also, there was no allocation of a risk of a mathematical error by MnDOT here. That's what Section 1504 is about when it says that no party can take advantage of an error. It's clear there is no allocation. Matthey did not assume a risk that MnDOT would make a mathematical error, and there's no reasonable reading of either the subcontract or the specifications that reaches that conclusion. Fourth, the question of damages. If the court were to remand this case back to the trial court for damages, which we don't believe it should, but if it did, the fact is that standard damages require the deduction of any money saved from the original contract price. So if it were sent back down, and if Storms came in and claimed $327,000, it would have to deduct from that $327,000 what it saved as a result of not having to supply the labor and materials for the original quantity. They have already admitted, as you just heard, that they did not put in any fixed costs. The only other provision, the only other thing that I can think of that would not be reduced as a result of the savings from not having to do the work would be the lost profits. We don't believe under 1903 that lost profits are available as damages. But if the court should conclude that they are, that is all that would be permitted to be recovered.
And is the prohibition on lost profits in the MnDOT spec in 1903, is that in the record?
My recollection is that 1903 is in the record, yes. Then finally, going back to this conflict between, I see my time is nearly up, and so I will close there. Thank you very much, Your Honor.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're in recess.